Now back to the show. This is The Law Show on CL 650.
All right, welcome back to the Law Show on CL 650. I'm Zach Spencer. We're talking about immigration and citizenship law with Rudy Kisher and Alex Stojkovic from MKS in downtown Vancouver. The end of this month, June, you're moving to your new offices. Where again?
We're at 688 West Hastings, so Hastings and Granville.
So a lot of people
Suite
know the
900.
The famous Burke's building there on the corner. You're right next door, right?
Yes.
Kitty corner to the Sinclair Center.
Yeah, we're looking forward to it. So we're having a whole new floor, and we're expanding space, so it's fantastic.
All right. Now, we talk a lot about people coming into the country, and your front line there working with not only businesses that are bringing people into the country, but also the people that are trying to get in. What is the major compliance that you have to have on the employer side to bring people into the country?
Well, it's 5 years ago there was very little employer compliance, and what happened in a summer, I think people will remember, there was a bunch of interviews on CBC about these McDonald's workers that were getting, they felt they were being exploited.
Foreign workers, right?
Foreign workers that were working at McDonald's and weren't getting paid what they were supposed to be getting paid. There was also workers in Saskatchewan, Canadians that were getting laid off and getting replaced by foreign workers, and this caused the Conservative government at the time to put in a bunch of regulations that would require employers to keep records and to make sure that they are compliant with the regulations that were set in place, to make sure that Canadians get chosen first for the job, and that foreign workers who are vulnerable aren't exploited. That's
a big umbrella, foreign worker, right?
That is a big umbrella, and I think what happened, unfortunately, with the government of the day was they took a sledgehammer to kill a fly, right? So because the press was so bad around this, they responded and said, we are going to make every employer that brings a foreign worker, we're going to make him accountable, to the federal government in some way. So now, if you go through this process called the labor market impact assessment, which is a very expensive process for an employer, it could take months to get. You're asking for permission to get what's called a labor market impact assessment from the federal government to say, can you please let me hire a foreign worker?
So you're basically saying there's no Canadian can do this job.
No Canadian.
Is that the basic?
Yeah, that's the basic. We've advertised, and we can't find a Canadian to fill this role. We've advertised usually for 4 weeks. We can't find someone to fill this role. The application, then the process can take several months after you've done the advertising. And for each worker that you're hiring, you have to pay an application fee, which you don't get back, of $1,000.
Wow!
So it's an extreme
for every single person.
For every single worker.
So if you are running a McDonald's and you need a storefront person running it, you've got $1,000 invested before you even hire them.
And you might not even get that application approved. So you can imagine you're hiring for 20 of them, it gets refused. The government keeps the $20,000 for what amounts to probably about 30 minutes of work.
Now, that being said, there was no fee for any of this prior to 2012. Yeah. To take it back a bit further, I mean, the previous government largely expanded on the back of listening to business groups in Western Canada, the old temporary foreign worker program. And their expansion of what was then called labor market opinions and their facilitation of it, to facilitate, particularly in the time period between 2005 and 2008, which in Western Canada was a period of considerable economic growth.
And what were these people coming in for?
Mostly to work in a variety of jobs, depending on which province that you were talking about. In Alberta, they were coming to literally do everything. There were everything from car mechanic to oil
welders.
and gas, welders, to everything else. The program was expanded to the point where we had a big spike in foreign workers, and with the resultant spike in foreign workers, this got more attention generally. And then after the downturn in 08, some anxiety built up within the country, so that news stories that dealt with foreign worker issues, a case I was involved with in 2013, which was the HD mining case involving Chinese company, Canadian company actually, that was bringing in 200 mine workers from China to work on a particular mine, caused a lawsuit to be launched by two unions. This was the start of it. McDonald's, a year and 3 months later, was the culmination of it. McDonald's and Tim Hortons cases. And for that year and a half, in between, there was a Royal Bank story involving iGate, an outsourced tech company in India that took all these jobs away. Yes, exactly. So really, a lot of residual anxiety about jobs in Canada played out here, and the government, largely responsible for this expansion, beat a very, very quick and very aggressive retreat and responded by a compromise, which was relaunching the program, but making it more expensive because there were no fees up until that point. And then also throwing in all of these compliance requirements, which will really pick up.
Has the new Liberal government rolled back the fees?
Not at all. They haven't rolled back the fees, and they haven't rolled back the compliance issues. He hasn't had time. I mean, when I've seen sort of John McCallum, the Minister McCallum's been out here twice, and both times it's clear that he's been busy with the refugee file and hasn't really had time to look at this. So there's been no changes towards the labor market impact process, right? But this new compliance regime has given employers not only a bunch of things that they have to do in terms of keeping track of records, so they have to maintain the records of who applied for these jobs, right? So they have to keep track of the resumes and the applications.
So if you advertise for the 4 weeks and you have 6 people come in, you have to keep the resumes and who the
for 6 years,
and then because they could say, well, why wasn't this person good enough?
Exactly. So they've got a major compliance regime in that, and then you have to keep records that your foreign employee was actually paid the rate that he was supposed to be paid, and that he worked the hours that you said he was going to work. Now you can see where this can get a little bit out of whack when you look at sort of higher skilled workers. For example, somebody coming in maybe who's a specialist in an engineering consulting business comes in to consult, and he's working a lot of hours and he's getting paid well. It doesn't matter that he's, what I would say, probably not at risk. The government has said you've got to keep records now of how many hours he's working, what he's getting paid, and exactly what he's doing, and you've got to maintain those records for 6 years. And we're going to audit, and what the government has decided is we're going to audit 1 in 4 employers. So anybody who uses this system over 4 years has a likelihood that they're actually going to get audited. And the
give an example. Say you have the new Nordstrom store downtown, right? And they bring in an American executive up to run Nordstrom Canada, maybe a vice president. Yeah. So I'm making this person up, but say this person exists and he's making good money, or she's making good money, maybe several $100,000 a year. You're saying that person isn't at risk. Why should they have to do basically a log of the hours they work? And all of because they're not at risk. This was all set in place to protect the McDonald's and the Tim Hortons worker.
Exactly.
Right?
That's where I think it's gone too far. Right. The pendulum has swung. Protecting sort of semi-skilled and people at the lower wage, the lower spectrum of wages. I can understand how Canada may have a responsibility to sort of make sure that those people are getting paid what they're going to say. They're in a vulnerable position. They come here, they can get removed. They don't have resources. Somebody, for example, your CEO of Nordstrom's is well-educated, speaks the language, has lots of resources. I don't think he needs a Canadian taxpayer to be making sure that he's getting paid for every hour he works. And the worst thing is the employer. So I advise, a company like Nordstrom's, I've got to tell their HR manager, you got to make sure you know how many hours that guy's working every week. And they look at me like I'm crazy. And I'm saying the problem is not only will you get reported by the government, they can fine you thousands, if not millions of dollars. I mean, that's the limit on the that they could be facing. Now, we haven't seen these fines actually being used yet. The government has got they launched out a second program in January, and these audits are now starting to see starting to be done. And we've seen we haven't seen a lot of them get the fines, but it's sitting there, and employers are anxious. HR managers are anxious.
That's the hammer they have.
Yeah.
Is that you better comply, and that does protect the lower worker in some way that they could be fined, right?
Yeah. But why not take a reasonable approach and say, for somebody earning over $60,000 a year, we think they have enough, they've got enough resources to go get legal advice if they don't feel they're being properly compensated.
Now that's to deal with labor market impact assessments. They've also rolled out in a new regulation 209 that was brought forward in December of 2015. They've brought in, and actually they've been collecting this since February of 2015, I should say. No, so December of 2014 they launched this. February it became actual of last year. Every single employer who hires a non-labor market impact assessment work permit that's not open, so anyone who comes in on a free trade agreement or on an exception like an intra-company transferee, they have to register that employee, which they never had to do prior to last year. The terms of their work, the wage that they're being paid, and pay a $230 employer compliance fee, and also be subject to audit, just like in the situation with labor market impact.
That's the more likely avenue for the person I described.
Yes.
A senior person at a big company coming from the U.S. into Canada would probably take that avenue more than the traditional foreign worker, right?
Yeah,
but
exactly.
even so, though, that company is now subject to an audit based on information that they've provided, very similar to what was provided in a labor market impact assessment, as well as paying a fee that didn't exist prior to last
and
year.
to top it all off, even if there's not an employee-employer relationship. So you can imagine a firm up here hires an engineering company in the States, and they send up an engineer who's not an employee-employer relationship. So there's really no...
So mining company A hires an engineer from the U.S. to come up and assist with their mining operation.
And they're allowed to come in and apply for a work permit at the border under NAFTA, right? Because professionals, you know, they're highly sought after. They should be mobile. It helps the economy is the thought
But mining group A has to account for their
hours now,
right?
And that they were paid correctly. Meanwhile, they have no control over that,
None.
right? And who are we protecting here? It seems to me a whole system that's been, you know, basically it's been built without a lot of thought. And we had the conference here. I raised it at the conference we had a couple months back. We had the directors of both HR Service Canada was out here and CBSA, and their typical response was, "We're going to conduct these audits. We're conducting, you know, 1/4 of all employers that use this system are going to get audited every year, and those are our marching orders, and we're not changing them." There doesn't seem to be any concern about where the tax dollar is going on this.
But it seems to me, having had these conversations with you over several months, the pendulum seems to swing one way and then the other. You think it'll swing back?
Well, I don't think so. I think, look, long term, the lessons of the last 5 years on the temporary foreign worker issue is that politically this is never a good issue for government.
It's a hot potato, right?
It doesn't matter how much you're getting lobbied by business groups. There's a limit to how much benefit you can get by being too liberal on this file, liberal, small l liberal. So in my view, I don't think the current government is going to make it much easier on the foreign worker front. Their focus is different. Their focus is other issues. I think maybe making it easier, pathways to permanent residence to be easier long term. I think that's a realistic place that we can see the government moving to from a policy perspective. But certainly making it easier to bring in foreign workers, I can't see that happening.
Well, and it's not, I mean, to me, the problem is not so much making it easier. What they've made it here is harder to actually stay within the law that they've written, right? They put in all these compliance requirements that make no sense. Nobody sees the purpose of them, but now they're having to spend resources on them and worry about, you know, what is the government going to audit me on this?
And come
if
back.
they are, and I have to keep those records for 6 years.
When we come back, you touched on it a moment ago, permanent resident cards and renewals, delays, and what's going on with that whole situation within government. We'll pick up that when we return on The Law Show on CL 650.
There's more of the show still ahead. This is The Law Show on CL 650.